case briefs, and so much more. LSData's got what you're looking for.
Margaret Binco, a woman who left behind 4 wills, was at the center of a legal case, Kroll v. Nehmer, that shook the established principles in will and estates law in Maryland in 1998. Initiated by a dispute between Binco's brother and the person who offered the 1985 will for probate, the major contention revolved around whether Binco's 1985 will was effectively revoked. Interesting enough, the 1980 will was termed void as it had been altered. Despite Binco personally voiding her 1985 will when implementing a new one in 1990, the lower courts startled observers by admitting it to probate. Even more intriguing, her subsequent 1990 and 1994 were deemed invalid as well. The unexpected admission to probate by the lower courts was justified using the doctrine of dependent relative revocation, a doctrine that had unprecedentedly never been applied in Maryland. However, this seemed to call for appeal, and the Court of Appeals of Maryland saw it fit to delve into the case. The legal battle reached a climax when the Court of Appeals concluded that the lower courts had erroneously applied the doctrine, allowing the admission of an overtly void 1985 will to probate. Indicating a clear breach of Section 4, 105 of the Estates and Trusts article, the court declared that Binco intended to revoke the 1985 will, and no legal fiction could cloud her intentions. Emphasizing the importance of careful examination of circumstances, the court took immediate action. The case was remanded back to reverse the orphan's court order that had originally admitted the revoked will. The court also stressed that it has no authority to fabricate or edit a will differing from what a testator had inscribed. In a turning point for will and estates law, this verdict underlined the dominant role of a testator's intention over the doctrine of dependent relative revocation. It magnified the importance of validating a revoked will only after meticulous examination of circumstances and reaffirmed that a court cannot overwrite the testator's command. Thus, even in the presence of multiple wills and legal complexity, ultimately it is the testator's intention that steers the journey of a will.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.